Good morning. Good morning. Please take your seats. I'm Ted Ruger, the Dean of Penn Law, and it's my great pleasure to welcome you here today for this year's Sparer Symposium, an important event in the annual life of Penn Law. The symposium honors the late Edward V. Sparer, who dedicated his career on the faculty here at Penn Law to helping students see the law as an engine of social change and as a vocation that could bring greater justice in this country and around the world. His message is as relevant as ever today, and the role that lawyers play in bringing about justice, in representing minority groups, and representing those who don't have a voice in the current political climate is as important as ever. So this work continues, and we honor it and explore many of the issues that Professor Sparer would have been interested in today's symposium. The history of this symposium begins in 1983, when Professor Sparer founded Mobilization for Youth Services, the first neighborhood youth legal services program in this area. That year he also founded the Columbia Center on Social Welfare and Policy and Law, which was the first national support center for legal services. In 1984, building on the work of those two organizations that Professor Sparer started, this symposium began to be convened every year. Today and every year since 1984, this symposium has been a hallmark event in the annual life of the law school. It is planned and brought together by the law school's flagship Toll Public Interest Center, and led, like most good things at Penn Law, by our students, the Toll Public Interest Scholars, who I'll turn it over to in a moment. This symposium brings together students, faculty, practicing lawyers, policymakers, journalists from Philadelphia and around the country to provide insight into the dynamic relationship between scholarship, legal practice, policy making, and representing the rights of individuals. This year, many months in advance of the November election, I should say, our Toll Public Interest student scholars wisely determined that no subject would be more appropriate to talk about in January of 2017 than our divided political regime and the implications that division and divisiveness has for the rights of individuals, and then the role that lawyers, particularly public interest lawyers, can play in a regime that is so divided normatively and politically. It was a prescient choice. It is never more as important than when we gather today to discuss the role of public interest lawyers in a civic discourse that does seem not only divisive but unsympathetic and indeed sometimes hostile to the rights of certain groups in society, which many of you work on behalf of every day. So this is could not be more important, the discussion we're going to have today. We see not only a division, and I should say, we're very interdisciplinary here at Penn Law. There are political scientists across the street studying quite statistically and empirically the fact that the 2016 election, whether you break it down by ward or zip code or county, was the most polarized and divisive in the past 50 years. We don't need an empirical study to show that. We can look at the map with the red and the blue. We can engage with our own experiences. And we can think, I think all of us ought to think about the problematic nature of this division, not just in the red counties and the red zones, but also in the blue counties and what sometimes may be perceived as a blue bubble, be it academia, be it Philadelphia. I think this election kind of gives us lots to think about this division, the way it affects our normative culture, the way it affects the way we think about things. And we're exploring all of those issues at Penn Law. We're going to explore some of them today. Clearly, it also is a call to understand and appreciate the role that lawyers and public interest lawyers and scholars and students play inside and outside of the government in defending rights and extending the basic protections for human rights, equality, environmental protection, many of the causes that you all work on. Your work, the work that you're engaged in now, the work that our students are about to launch into work on, is never more important. So today we engage with with these issues and really kind of very much in the spirit of Edward Sparer, who combined a passionate concern for the poor with intellectual rigor and a profound conviction that the problems of poverty, which often seem intractable in his era as today, are indeed solvable with the right kind of legal and policy expertise and commitment. Looking out at you today and this full room of students, scholars, practitioners, I feel that commitment, and we will talk today about the ways in which, in what is a difficult and divisive political climate, this work continues, and we honor the legacy of Professor Sparer. I will turn it over really to those who drove this symposium with their vision, and that is the Toll Scholar students. And I want to thank particularly the Toll Scholars, the 2Ls, the 2L Toll Scholars in the class of 2018, who were the real organizers of this. Tom Campbell, Nick Hall, Akbar Hussain, Sarah Lynch, Layli Shabani, and Addie Rolnick. I just want to acknowledge their great work. Also my staff colleagues, Hillary Wiesel, Arlene Rivera-Finkelstein, and others in the TPIC Center. And although they're not present, the generosity of Bob and Jane Toll, who continue to make Penn Law's Toll Public Interest Center one of the foremost drivers of public interest work, quite literally training the next generation of public interest leaders who have organized this symposium. So welcome to all of you, and we'll get into the day's events. To launch us off and further introduce, it is my pleasure to introduce our 2L student, Tom Campbell, native of New England, graduate of University of Vermont Honors College as an undergraduate, and a current Penn 2L and Toll Scholar. Thank you, Tom. Yeah.
Thank you very much, Dean Ruger. On behalf of all the Toll Scholars, thank you for your ongoing support of public interest at Penn Law and your devotion to seeing it continue to thrive and flourish. Those of us in the class of 2018 are privileged to be the first class to have had you for our entire law school journey. You have already demonstrated yourself as being an engaging academic and personal mentor, and as an important figure in the campaigns that make Penn Law such an amazing place to work, research, and learn. In a week, we usher in the beginning of a new administration and what many may consider a new chapter in our great nation's history. And though we come together to discuss our divisions and differences, we as Toll Scholars felt it was important to frame this conversation, to explain why we think it is necessary and why many of you have chosen to attend today. After such a divisive campaign, we are here today not in spite of our differences, but to acknowledge and understand them in order to cultivate the diversity of intellect and identity that makes Penn Law so collegial and this nation so celebrated. Just a few weeks following the inauguration, Penn Law will be hosting its annual Public Interest Law Week, welcoming those experienced individuals who have devoted their lives and their careers to public service. I mention this not only to promote the series of events, which does promise to provide the kinds of intellectually engaging and professionally inspiring conversations that we will be having today, but also because of its theme, unity. You will find that unity also binds many of the events of today's symposium. Today, we have the privilege of having a conversation with some of the most knowledgeable experts in their respective fields to discuss the politics and policies of the 2016 election, and most importantly, the important steps that we can take to move forward. Many of our guests are attorneys, practitioners, policymakers, and academics. All of them are advocates. We will examine the state of voting rights and restrictions, discuss our fragile criminal justice system, analyze the evolution of the media's influence in politics, evaluate controversial proposed national security policies, and finally, discuss the role of a two-party system in a world of campaigns that are funded largely through super PACs and large single-payer donations. So we thank all of you in attendance for giving your time to these issues, both to be here and present today, but also after you leave, devoting your careers to these issues. And we also thank our esteemed guests who've so generously given their time and expertise. Lastly, we would like to thank those in the Penn Law community who have made this possible. Were it not for the generous funding provided by the tolls and by the dean and the work of the student volunteers that are with us today, we would not be able to have these conversations. Those of us who had the opportunity to organize panels relied heavily on the support of Penn Law faculty as well as the staff of the Toll Public Interest Center, especially Hillary Wiesel and the Associate Dean for Public Interest Programs, Arlene Rivera-Finkelstein. Hillary and Arlene truly made planning this symposium a privilege and a pleasure. And now, I am happy to introduce my classmate, study group partner, and dear friend, Sarah Lynch, who will moderate our first panel, Behind the Curtain, examining the impact of voter disenfranchisement in the 2016 election. I welcome you all, and I ask that you please give our panelists a moment to come and get situated up front. Thank you very much.
Thank you, Tom, and thank you, Dean Ruger. As Tom mentioned, this panel will be about voting rights. It's called Behind the Curtain, Examining the Impact of Voter Disenfranchisement in the 2016 Election. You will, if you have questions, please jot them down. We have a couple of volunteers around, student volunteers with note cards, and they will collect your questions at the end, and that way we can have a nice conversational flow and get all of your questions in at the end. To start, let me introduce my esteemed panelist. Just to my right here is Professor Kreimer. He is the Kenneth W. Gemmill Professor of Law here at Penn Law, where he teaches and specializes in constitutional law, constitutional litigation, and the First Amendment. To his right is Nina Perales. She is the Vice President of Litigation at MALDEF, the Mexican-American Legal Defense and Education Fund, specializing in voting rights, including redistricting and vote dilution cases. To her right is Dave Daley. He is the former editor-in-chief of Salon and the current CEO and publisher of the Connecticut News Project. He is the author of a book that, to borrow Fresh Air's Dave Davies' description, the title refers to a crude term for a political dirty deed done cheaply, rat-fucked. The true story behind the secret plan to steal America's democracy. His book discusses partisan strategies to control redistricting and gerrymander to extreme partisan advantage. To his right is Caitlin Swain, a civil rights attorney currently based in North Carolina, working with Reverend William Barber II. Her work includes both litigation to advance voting rights and grassroots community organizing efforts in the Moral Monday movement. We'll start with Professor Kreimer. He will explain the general overview of voting as a fundamental right and the constitutional landscape protecting the right to vote. He will start with a historical analysis of voting and the Constitution and conclude with an explanation of Shelby v. Holder, a 2013 Supreme Court decision that struck down parts of the Voting Rights Act. Thank you.
Okay, so I'm here, I'm here to some extent as the Ghost of Christmas Past. I want to try to set up the landscape that the folks who are actually on the ground are dealing with, and to put what we're about to hear in some sort of historical perspective. So the first point is there is no constitutional right to vote, right? The Constitution as adopted at the federal level simply said that the right to vote in federal elections, and there were only elections for Congress at the time, was to be allocated on the basis as the same way that the states chose the most numerous branch of their legislature. Whatever a state did, was applicable to the federal government, but the only limitations on the states was a vague adjuration there should be a Republican form of government. Most states had property qualifications, but they differed from state to state. There were a variety of different bases on which people could or couldn't vote, and the federal government didn't say anything about it. That was the state of affairs for the first 80 years of the Republic. The fact is that most of the struggles over the right to vote were political struggles. Jacksonian democracy largely eliminated the property qualification, but a series of other qualifications existed as a patchwork across the country. At the time of the Civil War, that was, quote, the right to vote. There was none. The 14th Amendment did impose an obligation of equal protection on the states, but didn't say anything explicitly about the right to vote except in Section 2 of the 14th Amendment, which actually said that the representation in Congress of states would be reduced if they did not give the vote to male inhabitants 21 years old who were citizens. Except, said Section 2, if the people were guilty of rebellion or crime. So again, we have a kind of photographic negative that there is some incentive to provide the vote to males who are citizens who are 21, and an assumption that the exclusion of people who have committed crimes is okay. 1870, the 15th Amendment fills in at least one blank. The states cannot deny people the right to vote on the basis of race or color or condition of previous servitude. Other than that, the Constitution says nothing. And indeed, in 1875, in Minor against Happersett, when a woman comes forward saying one of the privileges and immunities of citizenship is the right to vote, and the state is denying me that privilege and immunity of citizenship, the court says no. There is no right to vote. It's entirely in the jurisdiction of the states. In 1886, Yickwo against Hopkins, in dictum, makes a very fundamental point. It says that the right to vote is a fundamental political right because it's preservative of all other rights. Quite accurately, it observes that the ability to protect oneself in the political process is a function of the right to vote, and it's important. But again, this is entirely in dictum. And during the next 80 years, the Supreme Court doesn't intervene, and the states very consciously begin to pare back the right to vote in a whole series of different ways. The 1901 Alabama State Constitutional Convention explicitly said what we're trying to do is to minimize black political power consistent with the 15th Amendment. We can't discriminate on the basis of race explicitly, but we've got other ways to approach these matters. We can require literacy tests. We can require payment of a poll tax. We can require that there be good character determined by registrars. We can require that you have to be vouched for by somebody else who already has the right to vote. And my favorite, as a constitutional law professor, you can require that people be able to understand and interpret the Constitution. And in the North, similar limitations. By the middle of the 20th century, 29 states had literacy tests, not just the South. States increasingly had onerous registration requirements, tax-paying requirements, and the right to vote essentially rests again with the states. Breedlove against Suttles, 1937, the Supreme Court upholds the poll tax. Lasser against Northampton voting board upholds literacy tests under the Constitution. It's only in the 1960s things begin to change. What changes? Well, a series of things. First of all, the Supreme Court begins to get involved under the Equal Protection Clause. 1964, Reynolds against Sims, the Supreme Court once again says other rights, even the most basic, are illusory if the right to vote is undermined, and when Alabama has a disparity in voting power, that a rural county, every 6,700 voters can elect one representative. In Mobile, Alabama, it takes 104,000 voters to elect one representative. The Supreme Court says that sort of inequality violates the Equal Protection Clause. The people of the United States adopt the 24th Amendment prohibiting poll tax in federal elections, but not in state elections. But in 1965, Congress adopts the Voting Rights Act for the first time, addressing voting rights. What does the Voting Rights Act do? Several things. First of all, it prohibits abridgment or denial on account of race. And over the years, that is fleshed out to require that states not only consciously not discriminate on the basis of race, but also that they not adopt provisions that result in abridgment on account of race. Second, the Voting Rights Act of 1965 imposes a requirement that in areas where there is low levels of voting participation, less than 50% in 1964 or 68 or later 72, that before the states change requirements regarding voting, it has to be pre-cleared by the Justice Department to determine that there was no purpose or effect of abridging or denying on the basis of race. So states can't play whack-a-mole. Once one requirement is struck down, they can't impose another. Rather, they have to go through the Justice Department and show there was not a purpose or effect of denying or abridging on the basis of race. What are these covered counties? Well, mostly it's states in the Old South, which had previously adopted racially exclusionary policies. The other thing that happens during the 1960s is that the Supreme Court begins to say that this notion that the vote is a fundamental right has some teeth to it. The poll tax amendment, 24th Amendment, eliminates the poll tax at with respect to federal elections, but doesn't say anything about state elections. Harper against Virginia Board of Education, Board of Elections, says that the right to vote is a fundamental right if distinctions are made among people on the basis as to the right to vote. That requires a compelling justification, and there's no compelling justification for poll taxes. Poll taxes are invidious discrimination. Poll taxes at the state level are held to be unconstitutional. So we've got a series of different limitations. There's a limitation on malapportionment. There's the Voting Rights Act, and there's the fundamental right limiting the ability to exclude people from the right to vote. Over the next 3 decades, that's the matrix in which discussion evolves. 2 sets of final changes bring us to the current day. First, the court increasingly distinguishes between economic limitations on the right to vote and a series of other sorts of limitations. McDonald against Board of Elections, the state refuses to provide absentee ballots to people in jail. Anderson against Celebrezzi, it imposes limitations on who can get on the ballot. And finally, Crawford against Marion County, the court reviews a requirement of voter ID. And the court begins to move from a requirement that there be a compelling state interest to a looser balancing test, asking the question of whether the degree of infringement on the right to vote is justified by some corresponding level of state interest, a much looser set of tests. That's the world we live in today with respect to the right to vote limitations in general. The second thing that the court does in Shelby County against Holder is to say that that coverage requirement that was adopted originally in 1968 and then readopted on the basis of 1972 elections is unconstitutional and out of date. So that the pre-clearance requirement, the requirement that before states change what is done, they have to go through the Justice Department, is no longer applicable. The Voting Rights Act still imposes a limitation on actions that have the purpose or effect of eliminating the right to vote on the basis of race, but now it's up to the plaintiffs to prove it. And once one limitation is struck down, the states can come back with another. Well, what happens after Shelby County is decided? One of the things that happens is that in a series of covered jurisdictions, the states adopt new limitations of a whole series of varieties that the panel will be talking about. And now, rather than having the burden on states that exclude people from the vote to show that there's no racial intent or effect, it's on the plaintiffs to show that there is. In terms of the impact on the national election, it's not clear that the elimination of the pre-clearance requirement actually was what made the difference. Pre-clearance, voter ID and limitations are adopted in non-covered states. And Crawford, the case that has this more relaxed approach, is really what makes the difference there. One last point. If you try this at home, remember that states have their own constitutions, which may be more protective than federal constitutions. I say this because the only interaction I've actually had with this on the ground was I helped out a bit in the Pennsylvania state constitutional challenge to Pennsylvania voter ID, the Applewhite case, where we actually won. Didn't actually carry Pennsylvania last time, but at least the people got to the polls.
So now I'd like to turn this over to Caitlin. How does the whole history of voting rights and the constitutionality of certain limitations, how does this affect real people in your experience in community lawyering?
Thank you. Good morning. I'm so glad to be here and to be representing For Justice, which is the organization that I work with, which is a racial justice movement lawyering organization based in North Carolina. And we have been working for the last 3 years on behalf of the North Carolina NAACP and the Moral Mondays Coalition to support a fight back against the voter suppression and vote denial tactics that the panelists here have just given an overview of. How is this affecting real people? We, in North Carolina, saw a series of efforts passed by the North Carolina General Assembly, starting with a redistricting strategy, which my co-panelists will speak more about shortly, that changed the balance of power in the state of North Carolina to allow for a supermajority. That means three branches of government, all in the control of one party. Both branches of the legislature, the governor, and the Supreme Court, all in the hands of the same party. When that happened, directly following the Shelby County decision, within a month of the Shelby County decision, the General Assembly made the decision to pass a what the North Carolina NAACP has called a monster voter suppression law. And it is I will talk more about this later, but it was a law that went after 5 different methods of voting access that were disproportionately used by African Americans and Latinos in the state of North Carolina. Our clients were at the front leading edge of speaking up against this effort to suppress the right to vote, and leading a moral fight back to say that in this time we cannot move backwards, we need to move forwards. So I just want to speak about one of the plaintiffs in our lawsuit that ultimately resulted in a historic victory in July, overturning that law after 3 years of battle, and that is Mrs. Rosanelle Eaton. Some of you may be familiar with her story. She was 94 years old when we started working with her. She is an African American woman who has played a role in registering more than 20,000 voters of all backgrounds to vote over the course of her lifetime. And she herself was subjected to a literacy test in North Carolina when she first attempted to register to vote. So in her lifetime, she has seen not just she has seen the entire span of her life's work now put on trial again in just the last 3 years. And what something that she said to us at the start of the litigation sticks with me, and that is that she's devoted her life to this work. Now she wakes up and she does not know if she has the correct voter ID to be able to go to the ballot in 2014. She went on 10 trips back and forth to the DMV to try to get assistance to get the correct ID with her correct name on it. And she said, "Caitlin, if we can win this before I die, it will prove to me that there is a higher power." And I think that is a sad statement about where we are morally in this country, that a woman like Mrs. Rosanelle Eaton, who fought so hard, is once again on the witness stand speaking up for the rights of Black and brown people in this country, who are working to just have equal access to the ballot. We'll stop there.
Thank you. I'd like to turn to Nina and talk a little bit about strategy. So as we kind of discussed, the Voting Rights Act, Section 4, the formula was determined not to be unconstitutional and struck down, leaving Section 5 defunct. But the Voting Act still provides avenues to get jurisdictions back under federal preclearance. Could you share what your arguments were before the district court in the Southern District of Texas related to this issue, and how did the judge rule?
Sure. Shortly after the Supreme Court decided the Shelby County decision, and the news went nationwide that previously covered jurisdictions would no longer have to declare their voting changes, the mayor of Pasadena, Texas, which is right outside of Houston, got a glorious idea to change the city's election system. And in the city of Pasadena, Latinos had been mobilizing in greater numbers. They had been registering and turning out, particularly in the most recent election, which had happened because we have municipal elections in the spring in many places in Texas, about a month or two before the Shelby decision. And the mayor, who had been in public office for many, many years, saw that his city council was now balanced evenly between Latino selected candidates and Anglo selected candidates, and that perhaps one more election cycle would see the council tip away from his control over the city. And Latinos hadn't just been mobilizing for the sake of mobilizing, although it's always great to register and vote. Latinos felt that their side of town had been neglected in the distribution of city resources. Latinos had pothole-ridden streets, places with no sidewalks where children had to walk in the street to school, flooding and drainage problems. It rains a lot in Houston, and so sometimes after a big rain, the toilets would flow backwards in Latino neighborhoods in North Pasadena. And this is, of course, in stark contrast to the very beautiful conditions and maintenance by the city of the primarily Anglo-South side of Pasadena. So Latinos were on the move, registering and voting for a reason. They wanted more resources on the north side. Shelby County comes down. 3 days later, the mayor announces he's going to form a citizens commission to consider bonds first, city bonds, not too controversial. But within about 2 weeks, he had shifted their mission over to considering changing the way the city elected the city council in a way that was pretty obvious to everybody would make it impossible for Latinos to be able to elect a majority of the council. This is an old technique that we've seen in many, many places where there's a minority community at large elections. Instead of having 8 neighborhood-based districts, the mayor suggested not a complete change, but let's have 6 neighborhood-based districts and 2 at-large seats. And this would have dropped Latino influence by 1 seat and moved those at-large elections squarely into the hands of the Anglo electorate. And I can see the nodding heads. You're probably imagining Latinos and Anglos vote pretty differently in Pasadena when it comes to candidates. And that was certainly true. When SCOTUS blog called up Mayor Isbell and asked him why he was doing this, he said beautifully, because the Justice Department can't tell us what to do anymore. And Mayor Isbell testified at trial that he knew that if Pasadena was still under the preclearance requirements of the Voting Rights Act, and that if Pasadena had submitted this proposal to the Justice Department, it would have been rejected under the Voting Rights Act. It's a simple administrative procedure. The Department of Justice would have said, this is not a good thing for Latino voting strength. We're going to say no. And it had happened in Beaumont and Galveston, which aren't too far away. And Mayor Isbell testified that he knew that. Nevertheless, he pressed on because the Justice Department could no longer tell them what to do because of the Shelby decision. And so this was, when we filed suit, one of the first post-Shelby, besides the North Carolina case, one of the first post-Shelby challenges to a reorganizing of election system. And we argued to the court, not only were these changes dilutive in effect, meaning they made it more difficult for Latinos to elect their preferred candidates, but that it was also intentional racial discrimination under the 14th and 15th Amendment. Those of you who have tried in 10 cases know it's very difficult to persuade a federal judge to hold that there was intentional discrimination. But we had a great coming together of some wonderful evidence, some amazing clients, some fantastic witnesses, some exercise of rather poor judgment in what the defendants were saying in their depositions. All came together very nicely at the end, and we were able to secure last Friday, a week ago today, a ruling in our favor, not just on discriminatory effects, but also that the city of Pasadena violated the 14th and 15th Amendment in racially discriminating, and the court ordered Pasadena back in under the preclearance system in something known as judicial bail-in, which is a provision of the Voting Rights Act that allows a federal judge, after finding intentional racial discrimination, to order a jurisdiction back in under federal preclearance. So we got everything we asked for, and we're very pleased. However, it cost millions of dollars. And we lost an election cycle, right, which was the 2015 election cycle, which was conducted under the discriminatory system. Latinos in Pasadena had expected by 2015 that they would have a responsive majority of the city council already looking at those potholes, at those drainage issues, right? But instead, we're in 2017. Keep your fingers crossed that the city of Pasadena does not get an emergency stay from the Fifth Circuit And maybe, just maybe, we can have a 2017 election that produces a responsive city council. But my clients are still waiting in the conditions that they have, because the loss of Shelby County meant that we had to litigate this issue, which meant the city had to spend quite a bit of money, and the plaintiffs had to wait. And it also took a big chunk of our time and resources as well. So the bottom line on this case, although it's been hailed as a victory, and it is that it doesn't change the fact that the loss of preclearance as a result of the Shelby decision has shifted all of this time and money burden over to plaintiffs who still fight even intentional racial discrimination in voting.
And before I bring in Dave Daley, I just want to return a little bit to how this connects to past discrimination and kind of the differences and consistency that we're seeing. So, Caitlin, this question is for you. The historian Eric Foner recently wrote, "Reconstruction, the era after the Civil War, witnessed a vast expansion of democracy, with black men for the first time voting and holding office in large numbers. And then a period of reaction, known by its proponents as redemption, in which these rights were stripped away. The Civil Rights Revolution was sometimes called the Second Reconstruction. Today, when it comes to voting, we seem to be in the midst of a second redemption." So, Caitlin, would you agree? Are we seeing a second redemption?
The word redemption is not the word I would use. But I do think that I think that the historical context is so critical in this moment, and really critical to the question of how race has been used to construct our democracy from its origin moments. The North Carolina NAACP and the Moral Mondays movement speaks about this time as that we are in a third Reconstruction era, not the third redemption, but the third Reconstruction. And that is that we are working to enter a time of reconstructing a fusion-based transformation of our society. What I would argue is that we are in the backlash to the third Reconstruction, and the only question is which comes first, and then who wins. And I think that many of us are taking a step back in this moment and asking questions about who will control and how is power going to be maintained in this time toward a racially just society. And I think that is the work that I believe in, and that is the work that in North Carolina, I think that there is a model for a resistance movement to a certain type of backlash that may be useful for the country right now to look to about successfully speaking up and using every method that is available: the courts, communications, the ballot box, as well as people power and grassroots organizing, and building real relationships. So that is my thought for Eric Foner.
I think that your comments will make many in the audience think about how we distribute power and how we apportion our different voting districts, which is a nice segue for Dave Daley. Dave, gerrymandering has been around for a long time. One of the first instances of gerrymandering occurred before our country's founding even, right here in Pennsylvania, when political leaders limited the number of representatives Philadelphia would have by strategically drawing district lines around the city. If gerrymandering's been around for so long, why should we be concerned now?
It's a great question. Thank you for having me, and it's a real privilege to share this with Nina and Caitlin, and who are doing such amazing and inspiring work in all of these states. In Texas and North Carolina, public interest lawyers who are on the ground in Wisconsin and Virginia, Maryland. All of these states are doing terrific work. You are absolutely right. The gerrymander has been with us for as long as we have been a republic, perhaps even earlier. The story that I tell is not a legal story so much as it is a political and a journalistic story that begins right after the 2008 election, when despairing Republican strategists take a look at a Democratic supermajority in the U.S. Senate, a re-elected Democratic majority in the House of Representatives, and a new president in Barack Obama. They take a look at the demographic changes that are happening throughout the country, and they say, we're in some trouble. A handful of strategists based something called the Republican State Leadership Committee, however, realized in 2009 that 2010 is a census year. It's a redistricting year. Every 10 years we reapportion and redistrict all of our state legislatures, and those, in most states, those state legislatures are the folks who are redrawing the congressional districts. What they realize is that there are fewer than 120 state legislative seats across the country that represent the difference between taking complete partisan control of the House of Representatives. They realize that if they can capture these 120 specific state legislative seats and tip control of those chambers, including right here in Pennsylvania, to their side, that they would have the ability to draw on their own more than 190 of the 435 congressional districts completely on their own. They launch a plan called Red Map, which essentially for $30 million, it goes into North Carolina, Pennsylvania, Michigan, Ohio, Wisconsin, a handful of other states, and the goal is to win these legislative seats and then to, in 2011, when these new maps are being drawn, radically redraw them in such a way as to lock in partisan control. And what we have seen is how effective that has been. In 2011, modern technology, the kinds of computer programs that are used now to draw these districts have progressed to the point that each and every squiggle of these maps can have direct, specific intent. As the courts have ruled in North Carolina, it can be sometimes surgical intent designed to carve people up. And the knowledge that the map makers have of who we all are at these levels, thanks to public records that can be added on to these map-making programs, thanks to the census data, thanks to all the demographic data, thanks to social media and then a cloud's worth of consumer preferences that can all be uploaded into the kinds of programs that draw these lines, has intensified to such an extent that what we have seen throughout these last cycles are maps that are virtually impossible for the Democratic Party to win on in many states, even when they get dramatically more votes. You see this in 2012 at the congressional level, but you also see it at the state level in North Carolina, Ohio, Michigan, Wisconsin. What you begin to see are veto-proof supermajorities for the Republican Party in states that are essentially 50-50, or in states where they often get fewer votes. And what you see from the legislatures in these states after that is an explosion of legislation on voter ID, on voter suppression, on eliminating early voting, on changing the number of polling places that are allowed, on limiting absentee ballots. And what you have is an explosion of intent and technology at a time that has taken the gerrymander from sort of an age-old tool into something that has, I think, contributed deeply to the fact that we are a 50-50 country, but we are living at all levels of that under the control of one political party.
Thank you. There is a Supreme Court decision where this kind of issue is called the political thicket, and I think that really nicely describes how complex it is for the courts to get involved in these issues. And returning to the doctrine, in Reynolds v. Sims, the court held that the Constitution requires voting districts to be equally populous. And so this was the one person, one vote standard that marked the court's entry into this so-called political thicket. And it opened the door to these controversial questions about how extreme does partisan gerrymandering need to be for the courts to strike it down, and how is race considered in that? So I'd like to ask Caitlin, what, in your experience with the Harris v. McCrory case, how does race play into these kind of partisan issues of gerrymandering?
So, I mean, one thing that I think is important to make clear is that no political party has the monopoly on voter suppression, and that throughout this country's history, the fight for the access to the ballot and full franchise has been marked by suppression that has taken many forms and has had many champions. But at the core of it is an effort to suppress rights based on race and color, and that has been about a project of maintaining control by a few, and limiting the opportunities, the lives, and dignities of citizenship and power for the whole. And in North Carolina, the red map strategy was very alive and well in North Carolina. It's been very well documented. The use of mapping programs that allow for the level of specificity that can pack and stack voters based on color, based on political affiliation. It's really astounding, and I actually think that the courts were a little slow to understand it because it was new. And the approach is not new. The technical ability to do it at the level of specificity was new. So in North Carolina, and this harkens back to something that Nina said earlier, we've lived through, North Carolinians have lived through now at least three illegal election cycles. That means elections that have now been found by either federal courts or state courts to have been operating under either one, illegal redistricting schemes, or two, an illegal electoral process. And I think that I should go back and just note that earlier I said, Mrs. Rosanelle Eaton said to me, I want to be alive to see this victory. And she was alive to see this victory, and she is alive today. And was there when we celebrated both the victory in North Carolina NAACP, which was similar to the Pasadena case, an intentional racial discrimination case finding under the 14th and 15th Amendment and under Section 2 of the Voting Rights Act. And then also the recent victories in the Covington case and the McCrory v. Harris case, which found that the redistricting processes were illegally used intentional discrimination to create maps. There's a recent development that in that case, which is that the Supreme Court has just granted a stay that is put a hold on the 2017 special election that has been ordered in the state of North Carolina to remedy the maps, and we are waiting for what the final decision will be there. But I think that this goes to the question of justice delayed can be justice denied. And goes back to, I think, the importance of a public outcry against the continued filibustering of looking at the reauthorizing the Voting Rights Act in this country, which I think should be in a common sense next step.
Great.
Which I'm sure our Congress will take up.
Fingers crossed.
To break in here, does anyone follow, I don't know the details, the Holder Obama initiative that's kind of in the background?
We were discussing this just prior to, and
So just, it might be worth sharing that if somebody can?
Dave?
Sure. I've done some reporting on this recently. So the Democrats were not ready for 2010. They were prepared to sort of fight the old redistricting battle. They were not ready for the technological precision and the new strategy that the Republicans brought to the gerrymandering battle in 2010, and they were late to recognize the effects of it. It has played out over the course of the last 6 years. In state after state, they now understand, I think, exactly what a hole they are in, both on the federal level and in state after state. So they have attempted to get ready for 2020, which is the next redistricting cycle. The president has said that his top political priority after leaving the White House will be redistricting. He has teamed up with Eric Holder on a new sort of umbrella organization that will involve the Democratic Governors Association, the DLCC, and kind of the other kind of big Democratic groups. Mark Elias, the attorney in North Carolina, who's been so effective, will be leading a lot of this on that side. The question is whether they're gearing up to fight on the same. It's not going to be especially effective if the Democrats simply try to rerun the red map play in 2020. It worked in some ways because the Democrats fell asleep at the switch and weren't prepared for it. That will not be the case in 2020. The Republicans are waiting for it, that they have already announced plans for Red Map 2020, and they've already invested a lot more money in it than the Democrats have decided to do. So there's less money, there's no element of surprise, and you still have the incredibly stout challenge of running on these maps. On top of which, the idea that pumping a lot of money in and trying to tip legislative chambers in super local races is kind of a bad thing for small d democracy as well. But if there is a legal strategy coming out of this, and in many ways the only successes that the Democrats have had at the congressional level have been through legal strategies that have challenged these maps. Their electoral strategies have not worked very well. But in Florida, in Virginia, where they've been able to mount legal challenges, they have gotten new districts and won seats.
Great, thank you. Returning to the doctrine just a little bit to parse out what's at stake here. Nina, could you describe, we often refer to all of these tactics to create barriers to voting as second generation barriers to voting. And there are three, as we discussed prior to this panel, there are three buckets to that. There's vote denial, and so in the case of the plaintiff that we heard of in North Carolina, not having the right ID, not being able to vote. Then there's vote dilution, as you so nicely described, as where certain groups are unable to elect their preferred candidate. And then we have what Dave Daley has described as redistricting. So what is at issue in vote dilution cases, and how is that different than redistricting?
There actually isn't much of a difference. I will say that when we talk about kind of the historical trajectory that many of our clients have actually lived through, Texas didn't get rid of some of the oldest measures that it had to suppress the vote until the 1970s, and then promptly picked up the newer measures. So it's been kind of a steady march for most of our clients who've been living through this. And we have things that have been struck down that we don't have anymore, like the poll tax, which, although wasn't explicitly racial, you can imagine if you're a mom or a dad and you can spend that $1.75 either feeding the kids or registering to vote, you're going to feed the kids, right? That's why the poll tax was so effective. We don't have it anymore. The literacy test was also hugely effective in combination with the grandfather clause, right? Because there were lots of white folks who couldn't read or write either. But if your grandfather could vote, then you were allowed to skip over the literacy test, right? And so many of those things have been banned, either by the Supreme Court or by amending the Constitution. But a lot of the narrative about ballot security and ballot integrity cloaks many of what we call the second generation measures of today. Voter ID is very explicitly wrapped in a narrative about ballot integrity, ballot security. These are words for those of you who've studied kind of election struggles in the past years. Those are very familiar words to us. They're always tinged with a sense that there's some people who are maybe shouldn't be voting, in the case of the narrative in Texas around undocumented immigrants, or maybe people whose votes are being manipulated somehow, and you'll hear talk about, oh, urban places, and oh, well, we're not sure these folks should be voting, or maybe they're not voting for the right reasons. And so this ballot integrity, ballot security is the narrative again today around voter ID, around other measures like proof of citizenship for voter registration. And I'd like to do this with you for a moment because I know there's been a lot of emphasis on voter ID. Mm-hmm. This is audience participation, please. Mm-hmm. If you have right now on your body government issued photo ID, and that would mean that you could vote under a strict photo ID law. Raise your hand, please. Look around. Okay, now pretend that we're at the county fair. You're all eating cotton candy, turkey on a stick, banging the mallet. I come up to you with a clipboard because I want to register you to vote, and we're in Arizona. How many people are carrying either a U.S. birth certificate, naturalization papers, or a U.S. passport? Raise your hand. Look around. Proof of citizenship for voter registration. Don't forget, because it's something that we're going to see in the new administration picking up a lot of steam. It tends to freeze the electorate in place. Even white folks can't register under these laws. But if you've got a state like Arizona that's changing very rapidly in its demographics, freezing the electorate isn't such a bad thing for a lot of incumbents, right? And so these newer measures, whether they come in the form of preventing you from registering or preventing you from voting, or whether through redistricting, they prevent you from casting a vote that means as much as the folks in the next district, are all kind of part of this package that we see now in this new retrenchment And so keep in mind that we're still taking that march, we're still moving forward in battling a lot of these measures. And I just wanted to add, we have to some degree been talking about racial discrimination in voting and then partisan gerrymandering. We've been sort of crisscrossing back and forth, but I don't want to leave people with the impression that the two can be collapsed because they're quite different. And there are many circumstances where minority civil rights lawyers, voting rights lawyers like myself, are on the opposite side of the case, not always on the V, but on the opposite side of the case from partisan political operatives in the courtroom, including those for the Democratic Party.
And to add to this, there's not just issues with access to the ballot. You describe issues related to vote weight and representation. Nina, you were deeply involved in a recent case, Evanwell v. Abbott. It was decided this past year by the U.S. Supreme Court. What was that issue in Evanwell, and what are the implications for Latino voting rights?
Evanwell was kind of like the nuclear bomb of redistricting for those who followed it, but for those who didn't, we've all lived in a world where the Constitution requires every election district to have the same number of people in it. That's the concept of one person, one vote. Nobody has very seriously challenged that idea until some crazy people in Texas decided to bring a lawsuit saying that we don't have to have the same number of people in every district. That's not what the Constitution means, even though that's what the Supreme Court more or less said over the years. We should have the same number of people who vote in every district. And that's what we should equalize. Now, the difference between people and people who vote, the first and largest group that comes out are children. So if you happen to live in an area, perhaps a suburban area outside of Dallas or Houston that has more kids per capita, already your election districts are going to start to warp, right? And if you happen to be a United States citizen and a voter in an area where there are relatively fewer U.S. citizens because there are immigrants in your community, your district is going to start to warp again. And eventually we'd have some election districts that are almost twice the size in terms of number of people in it than a district that might be nearby or up in East Texas where people tend to be older and have less immigrants. And so we saw right away when the case was filed that this was way beyond the kinds of redistricting and gerrymandering efforts that had come before, because it was striking at the heart of the first rule of redistricting, which is how many people ought to be in a district and how much balancing should we have across the districts. So I represented the Mexican American Legislative Caucus in Texas. We moved to intervene in the litigation, and however, it was so swiftly dismissed that we weren't able to get granted intervention. And then we followed the case up to the U.S. Supreme Court, where thankfully the Supreme Court decided to simply leave things as they are in Texas. Texas, like every other state, uses the same number of people in every district. But all it would take is for a state to decide that they want to use a different set of rules. And I believe that that issue will return to the Supreme Court and be a harder case to decide on its next trip up.
Are there political initiatives that you've identified where there are states that are trying to take this step?
Not yet.
Not yet.
I also think what was interesting as I studied Evanwell in preparation for this panel, that the Supreme Court focused a lot on this analogy of children's rights under a framework that would only count voters, because of course children are not able to vote.
And that was our strategy.
And I think it was a good one. I think it was well received. But we also recognize much of the conversation here is that so much of these issues relate back to race and racial discrimination. On the other side of the V, in that case, was an individual who was brought cases and at the Supreme Court to strike down affirmative action. And so that's just an interesting side note of what I've learned. So to bring it back to redistricting a little bit, and partisan gerrymandering, which of course is different and somewhat harder for the court to make a determination on because they don't want to address political questions. But in Veith versus Jubileer, Justice Kennedy hinted at the need for a basis to measure the burden on voters' representational rights in partisan gerrymandering claims. Essentially, he wanted to know what measurement could show us how much someone's vote has been diluted by partisan gerrymandering. And in November, a 3-judge panel in the Western District of Wisconsin struck down a state legislative redistricting plan in a case called Whitford v. Gill, and it was considered an unconstitutional gerrymander. The court relied in part on plaintiffs' use of an efficiency gap test that shows discriminatory effect. So Dave, could you please explain to us, the lay people, what the efficiency gap test measures?
Asking the journalist to get into the law questions.
It was something
yes.
that was designed by political scientists.
Exactly. The court over the years has said that they're open to a standard that measures partisan symmetry. The idea that district plans ought to treat parties essentially equally. They have, not been especially interested in questions of partisan intent. Those things have been, like pornography, difficult to define. But that they are open to the idea of being sure that votes translate into seats with equal efficiency. This is not the same thing as proportionality. It's not the idea that the share of votes and seats are identical. So the efficiency gap, which a handful of political scientists and law professors and very smart statisticians worked on, was designed in a way to get at the heart of what the court has said that they are open to looking at when it comes to partisan gerrymandering. Can you create a justiciable standard for it that is clear and easy to apply? Essentially what this is the difference between the parties' respected wasted votes in an election divided by the number of votes cast. Wasted votes are votes that don't contribute to a victory under this plan. They essentially come in two forms. They're lost votes for candidates who are defeated, and surplus votes for candidates who win in excess of what they needed. The idea is that when a party gerrymanders, you're either packing or cracking. You're either trying to pack as many votes of the other side as you can into as few seats as possible, or cracking them to dilute them across as wide, as many districts as you can. So this is designed to measure the extent of gerrymandering in a state with perfect partisan symmetry. Both parties would have the same number of wasted votes. Essentially, it's aimed at trying to eke out a 5-4 decision that would change the nature of partisan gerrymandering. And if you could create a standard like this, states would have to apply it when they are drawing their maps. What you see, according to the political scientists who worked on this, is that from 1972 through 2010, the level of gerrymandering as measured by the efficiency gap remains essentially constant. It spikes in 2012 to the highest peak in the modern era and has stayed there throughout 2012, 2014, 2016. And it does, in fact, lean in one direction. There are 7 large states with pro-Republican efficiency gaps of at least 2 seats in 2012. Florida, Michigan, North Carolina, Ohio, Pennsylvania, Texas, Virginia, not a single large state with a Democratic gap that large.
Well, stay tuned to see if Justice Kennedy is convinced that this kind of measurement will sway him. In the past, there has been a lot of plurality decisions about the justiciability of partisan gerrymandering. So we will see if and when the court takes up that question. So before I turn to our fabulous questions, thank you for your input in the audience. I'd like to shift the focus a bit to the future. This symposium is not only about acknowledging our country's divisions and investigating their roots, but it is also about bridging the divide and forging a path forward to create a stronger, more inclusive, and united democracy. So for each of the panelists, what advice do you have for law students, legal advocates, and other community leaders in our audience for what we should consider moving forward?
Okay, I guess I'm the first one in the queue. I guess strategically there are 2 points I would make. The first is, as I said, kind of in passing, if you try this at home, remember that there are a series of different fields of struggle. And even if one loses at one level, one can proceed to struggle at the other level. States' Supreme Courts are not bound by the evanescent majorities of the U.S. Supreme Court and can provide venues for seeking justice even when federal venues are closed off. The second, and I think probably broader point, is that lawyers marshal facts, doctrines, and norms. And that marshaling can take place not only in the courtroom. I think it's tremendously important to understand that over the scope of American history, it has not usually been the case that the struggle for justice has succeeded primarily in the courts, and it's never succeeded only in the courts. Talking to your colleagues, organizing, as President Obama says, grabbing a clipboard and running for office is something that you as lawyers can do, should do, and if we want a just country, must do.
I would say one of the great things about voting rights among all of our civil rights is that it provides an opportunity for such enormous engagement by everybody. You don't have to become a voting rights lawyer and spend your whole career doing this stuff. Although I welcome, if you do, give me a call, send me an email. But even just from voting forward, right? Don't miss an election. And particularly don't miss a school board or city council election. Even your water district, if you have tons of special districts in Texas, you need to vote and bring any person under 18, drag them with you, give them the sticker. Everybody can do that who's a United States citizen and isn't barred by other things like we have lots of in the South. But also, you can take election day off every year or plan to and join a hotline. You might spend the day helping people find their polling place, but that's a vote each time. If you're friends with somebody who's running for office, you can volunteer to drive people to the polling place who need assistance to go. You can be a part of a legal rapid response team who might be going to court on election day because a polling place that was supposed to open at 7 a.m. Didn't open, and you want to ask a court to keep it open for a little bit longer that day so the people in that neighborhood can vote. You could make a lot of money and give it to MALDEF or Justice Forward Justice, whichever way. There's about 1 million different ways that you can satisfy the urge to bring justice to voting, and I encourage you to think about all those different ways and to do it. Thanks.
I think that the kind of information we we have as voters about what has happened to our district lines in many ways is directly tied to the kind of work public interest lawyers have done in these cases. We understand the political strategies because of depositions and emails that have been uncovered. We understand exactly what the algorithms are. We understand how the strategists have talked to one another. And in Florida, where there was a fair districts constitutional amendment put into place banning partisan intent from the drawing of lines, the kind of work done by lawyers there uncovered that the entire process was dripping with it. I think what we need to really understand is that that these district lines are in many ways the building blocks of our democracy, that when they become twisted and perverted, that it leads to, there is a direct line between that and the kind of policy outcomes we see that are in many ways deeply undemocratic. And what we have seen, I think, is a real crisis of democracy in many ways. I mean, certainly the president the other night encouraged people to get out and grab a clipboard and run for office. That is increasingly hard to do. In North Carolina this year, 57 of the 120 House seats went uncontested by a major party candidate. The number was even higher in Wisconsin. It's up around 80% in Georgia. Because when you twist these lines in such a way that you don't have competition, when they are twisted in a way that votes are packed and cracked and stacked in favor of incumbents and entrenched interests, it becomes very dangerous and very undemocratic.
For law students in the room, we really believe that in this moment, we need lawyers, movement accountable lawyers, client accountable lawyers who are not coming out of law school just to pass the bar, but to raise the bar, to be a part of listening to what the truth is on the ground. When I came to North Carolina to sit down with our clients, I was coming to talk about education issues and criminal justice issues. That's where we started. And there is a crisis in education and criminal justice in the state of North Carolina. But what my clients said was, we have got to start with voting rights. Our power has been taken away from us to be able to express our vision of the future on education, on criminal justice, on the environment. And that is where we started. And they started with saying, this is our Selma. We brought that into the courtroom. We didn't leave it outside in communications. So I really value what the public interest community is doing at UPenn, but across all law schools right now. I think this is a time to be really encouraging lawyers to look for ways to be a part of movements and to listen to what people need rather than prescribe what is needed from the outside. So that is one piece. I do think the courts, the federal courts, are going to be maybe less hospitable to some of these claims. In the coming years, I think that we are on a trajectory that is moving us forward in victories on voting rights, and I hope that trajectory continues. But I think that having lawyers who are willing to look at state constitutions in the South, we have Reconstruction constitutions, and I think that there are exciting ways to use state courts in new ways. I also believe that investing in communications right now really matters, and having a free press that is engaged in exposing in disciplined ways what is happening is an essential component to democracy. And I'm going to say this, even though it may contradict something that we talked about earlier. From the vantage point of North Carolina, we believe that we need to start talking about the need to change the South in order to change the nation. That if we do not, if we continue to sort of concede the South as a place that we are under-resourcing meaningful political and personal liberation work, we are going to see this pattern over and over again in our country. And I think we have not fully addressed the impact of a Southern-based backlash that has happened over this last period. So I just encourage us to think about that while we do not. I don't want to historicize what has happened in the North and the deep problems in the North, but I do think we have seen a remarkable backlash post-Shelby that really must be addressed and resourced over this next period.
Great, thank you. I love that idea of movement accountable lawyering. We'll certainly take that to heart. I know, at least in my personal experience, I have so many unforgettable moments in the classroom, especially in Professor Kreimer's classroom, but also Penn has given me the opportunity to go out into the community and work, across the state, listening to people, and I've learned just as much about the law from them as I have from inside the classroom, so I take that to heart. And so in these last less than 10 minutes, I'll turn to the questions that you all have posed, not all of them, but some. First, this one is for Professor Kreimer and anyone else who'd like to take it up, but it ties in nicely to our next panel on criminal justice reform. What does the Constitution actually say about voting rights for people convicted of a crime? And what does this mean for access to vote?
Okay, so what the Constitution says is exactly what I said before. Nothing except for that little exception in Section 2 of the 14th Amendment where it says that the reduction of representation of states for excluding males who are 21 and citizens from the vote doesn't apply in the case of crimes. Part of the problem that we face is that in 1974, even kind of at the height of enthusiasm for voting rights and equality, Justice Rehnquist wrote in Richards against Ramirez that that exception for criminal conviction made it impossible to apply the general equal protection principles to excluding people from the vote for criminal convictions. Now, in 1975, that applied to 1.17 million citizens. In 2016, that's up to 6 million citizens. 7.5% of African American citizens, 13% of African American males. The exclusion from the opportunity to vote for people who have been convicted of crimes, we're talking about 20% of the voting population in African American population in Florida, 22% in Kentucky, 20% in Virginia, 17% in Tennessee. The question that that we face is whether or not the Voting Rights Act can be deployed against these mechanisms. Sadly, there are cases pending. The question of whether or not those will succeed is going to be a function of what the incoming Supreme Court is going to do. Last point on this, on groups that are excluded, Puerto Rico has 2.6 million people who are American citizens who can't vote for president or for a representative in Congress. D.C. has 400,000 people who can vote for president but can't vote for congressional representatives. So those are two other pieces of our country that simply are excluded.
Thank you.
Thanks for letting me use those slides.
I have a bit of a controversial question, but to heed Caitlin's warning about free press and freedom of speech and not to disappoint our keynote speaker, Beth Donovan, who will be speaking later, I will read it as it is. And I think this might be a good question for you, Nina. Do we see large or significant numbers of undocumented people voting in elections?
None. And believe me, there are people desperate to come up with an example. What we have seen, okay, so it's a big specter of undocumented folks because, of course, somebody is going to go 3 days across the desert without food and water and immediately first thing report to register to vote and vote, right? It doesn't make sense on any level, but it has extraordinary kind of gut appeal. And so we saw that voter ID in Texas was listed as an immigration control bill on many of the sponsors' websites. During deposition, it was incredibly frustrating because even after we narrowed them down to non-citizens as opposed to undocumented people, we discovered that there were many lawmakers in Texas who didn't understand that you could be a non-citizen and not undocumented. The whole category of legal permanent resident just kind of vanished. But also because they thought that if you had a driver's license, that meant you were a U.S. citizen. And so again, there was this kind of very confusing approach that people had in their minds. I don't want to underplay how incredibly compelling people find this idea that they have to protect the ballot from interference by undocumented immigrants or non-citizens. And it's a very hard conversation to have with people when you say it's not happening. Last session, I was testifying in the Texas legislature. I said to the person, the state representative who was talking about the bill, I said, there are no examples of non-citizen voting in Texas up to today. And he said, well, that's just rainbows and unicorns, isn't it? And I'm thinking, well, first of all, rainbows are real. So, I didn't say it. But what it sort of, that exchange captured was that he and I were living in two completely different universes. I mean, just two completely different universes. I've tried to talk about the very rare occasions on which a non-citizen does end up registered to vote. Sometimes there's a language barrier at motor vehicles, and you can register to vote through motor vehicles department. Sometimes people, through the lack of communication, end up getting registered through the motor vehicles department and then typically don't vote because they know that they're not eligible. Every once in a while, somebody is told if they've submitted their naturalization application, they can kind of get a jump start. But it's extremely rare, and usually when people find out, they're very chagrined. And it's what we call a mistake, right, as opposed to a fraud. However, all of those facts don't seem to weigh very much with people who are convinced that their elections are tainted through the participation of non-citizens, including our friend, the notorious anti-immigrant dude, Chris Kobach, who has now turned his attention towards elections and has been meeting with the new president-elect. And we don't really know where that's going to go.
Thank you. And in the interest of time, and so I can give our lovely audience a break, I'm going to end it here. But I just would like to conclude on Nina's thoughts about these two completely different universes. And sometimes it might feel that way, even here at the law school where we are collegial and we're all friends. Sometimes it feels like we're on two completely different universes or in two completely different universes. But today is about bridging the divide and using facts to do so, using empathy to do so, a true understanding of history, and even given the seriousness of all of the issues we're going to discuss today, I think with humor as well. So thank you so much for your sharing your expertise and your knowledge, and have a great rest of the day.